again, and welcome back to Criminal Law. This is the second lecture in the Elements of Liability module. In the last recording, we discussed the first building block of criminal liability in individual cases, the requirement of a voluntary act. In the process, we also discussed an important exception to this requirement, voluntary omissions, which are failures to engage in conduct that someone is both legally obligated and physically capable of engaging in. With this basic ingredient of liability covered, we're now ready to begin our discussion of the second ingredient that exists in individual prosecutions, what we'll refer to as mens rea, or the guilty mind. Okay, so mens rea is a big and complicated topic, and it's also a practically important one. So it's something we'll be revisiting throughout this semester. In this recording, I just want to introduce you to what mens rea is and discuss some of its most basic implications for criminal practice. In the process, I'm also going to teach you a few general things about the common law approach to the topic. This is all going to hopefully lay the groundwork for the next recording, which is where we'll dig into mens rea more deeply by focusing on the modern, model penal code-based approach to the topic. Through these recordings and the related readings and assignments, I'm going to try and present the topic of mens rea to you as simply and accessibly as possible. But if you're still feeling confused about things, say by the end of this recording or the next, that's okay too. Mens rea is a difficult topic that even the smartest jurists struggle with. And it's also one of those areas of law that can take time for students to learn and process. So as always, please be patient and kind with yourself. If the topic of mens rea doesn't come easy or immediately, don't worry. Just keep working at it. And know that I'm here to guide and support you along the way. Okay, so there are 3 learning objectives for today's lecture. First, I'm going to provide you with a big picture overview of what mens rea is, why it's required, and how it's different than the voluntary act requirement. Second, I'm going to teach you about 2 different important common law mens rea terms, intent and malice, as well as the different mental states that can be proven to establish them. Third and finally, we're going to learn about situations where mens rea does not apply, what's known as strict liability. In the process, I'm going to teach you about an important interpretive tool, what's called the presumption of mens rea, that will help us figure out when a statute lacking a mental state requirement should or should not be read to incorporate a mens rea requirement. Sounds good? I hope so. So with that, let's go ahead and dive in. So at the outset, the most important thing to know about mens rea is that while the topic's complicated, the basic idea behind it, that we should only blame those who act with a blameworthy state of mind, is both simple and intuitive. Because basing our moral judgments on the mental states of others is as familiar to us as the air we breathe. Indeed, the different mental states that accompany the things people do change the way we perceive their behavior, even when their bodily movements are similar. Think about the difference between a push, a pat, a grope, a swipe, and a caress. So these all largely involve the same bodily movement, but the intentions and context behind those movements are distinct. And that can make a world of moral difference. So this moral difference can be pretty intuitive. As Justice Holmes famously put it, even a dog can tell the difference between a stumble and a kick. But sometimes a bit more reflection is required because there are literally infinite variations in mental state. For example, think about the difference between the kick of a playful teenager or a kick of a scared adult who mistakes a peaceful friend for an aggressive attacker. Or consider the difference between the stumble of someone who's extremely intoxicated or who's belligerently running around an intensive care unit. Dogs probably can't appreciate these nuanced psychological differences, but humans can, and criminal statutes need to. Because when one human inflicts serious, irreversible harm upon another, people look to the criminal law to figure out both who's to blame and what the consequences should be. So that's why the criminal law places so much attention on the minds of criminal defendants in determining criminal liability and imposing punishment. Generally speaking, the criminal justice system does not punish people for reasonable mistakes or for unavoidable accidents. No doubt people who are reasonably mistaken or who perpetrate unavoidable accidents may cause severe, terrible, and irreversible harms for which the civil tort system might hold them liable. But in the absence of guilty mind, the criminal law typically views them as outside the scope of criminal liability. That's because mens rea is a fundamental requirement of criminal liability in individual cases. So our focus in studying mens rea is going to be placed on understanding mens rea's role in determining whether criminal liability exists. That is, for most of this lecture and the next, we're going to work on figuring out what kinds of mental states the government has to prove beyond a reasonable doubt in order to secure a criminal conviction. However, it's also important to point out that mens rea does more than help distinguish or draw the line between criminal and non-criminal conduct. Mens rea also plays an important role in determining the amount of punishment that someone receives through what's called the principle of proportionate mens rea. The principle of proportionate mens rea says that all else being equal, punishment should roughly track the guiltiness of a defendant's state of mind. This is the animating idea behind the law of homicide, which we'll be focusing on studying in later classes. As we'll discuss in those classes, homicide statutes go to great lengths to differentiate between mental states and to lessen sentences for people whose choices are less blameworthy than the paradigmatic case of a cold-blooded, premeditated murder. So, for example, a jurisdiction will typically reserve its most punitive consequences, whether the death penalty or life in prison, for people who intentionally kill after giving the decision careful thought and consideration. By contrast, someone who intentionally kills in the heat of passion, having been reasonably provoked, will typically receive a lesser sentence, having been convicted of the less serious crime of manslaughter. And where someone unintentionally kills, under circumstances where they were completely unaware they're creating a risk of death, their conviction and punishment will be mitigated further yet by the offense of negligent homicide. So the basic idea is like this. The paid assassin, the aggrieved parent who kills their child's bully in a fit of rage, and the negligent gun owner who mishandles their weapon may have all perpetrated the same wrongful act, killing a human being. But because of the important distinctions in mental state accompanying that act, the criminal law affords these individuals very different sentences in accordance with the guiltiness of their state of mind. Okay, so in short, mens rea plays two important roles in U.S. criminal law. First, mens rea ensures that blameworthy and only blameworthy actors are subject to criminal liability. And second, mens rea is a way of ensuring that people receive an amount of punishment that's at least generally consistent with their overall level of blameworthiness. Now, for mens rea to effectively perform either of these roles, criminal policymakers need to clearly articulate which mental states matter to the criminal law and which mental states criminal practitioners need to be able to understand to figure out what has to be proven beyond a reasonable doubt to secure a criminal conviction or a more aggravated punishment. So, it's a real problem that for centuries, the law of mens rea has been notoriously unclear. Indeed, although mens rea requirements are a deeply rooted part of Anglo-American common law, that common law has also produced endless confusion about what mental states the government needs to prove beyond a reasonable doubt to secure a conviction. One reason for this is that the legal definition of mens rea has changed a lot throughout the course of history. Originally, mens rea referred to proof of a guilty mind in a very general and vague sense. Over time, however, courts began to understand mens rea in terms of more specific mental states directed toward the social harm required by an offense. This evolutionary process ultimately led to better mens rea policies, but also caused some significant growing pains on the path toward justice. A good illustration can be found in the famous British case of Regina v. Faulkner. In Faulkner, a British sailor tried to steal rum that was being housed on a ship while holding a candle. Unfortunately for the sailor, things did not go as planned. In the course of trying to steal the rum, the sailor accidentally dropped the candle, which lit the rum on fire, and then caused the entire ship to burn down. So this was a pretty bad day for the sailor, but things were about to get a lot worse because the sailor was then charged with committing the crime of arson. In prosecuting the case, the government argued that the sailor possessed the mens rea of arson because of his generally guilty mind in wanting to steal rum from the ship. No doubt intending to steal is a blameworthy state of mind, and based on the early common law tradition of mens rea, a generally blameworthy state of mind that might have been sufficient. However, the sailor's attorney wisely defended against the charge, arguing that while intending to steal might be a blameworthy state of mind, it's not the blameworthy state of mind required for arson. Instead, the sailor's attorney argued it was only through proof of intending to burn the ship that the mens rea of arson could be met. Ultimately, the court agreed with this argument, holding that a generally blameworthy state of mind is not enough to support an arson conviction. Instead, only an intent to commit arson will suffice. Or to be more precise, I should say that only the intentions to commit arson will suffice. Because arson, like many other criminal offenses, actually requires proof of multiple mental states. So for example, to convict someone of arson, the government has to prove first that the accused consciously desired to burn an object. And then second, the government has to prove that the accused fulfilled that desire of burning an object while consciously disregarding a severe risk of physical injury to other people. So on the modern understanding of mens rea of arson, there are two mental states that have to be proven: the purpose to burn and the reckless disregard of a risk to human life. As we'll see throughout the semester, these kinds of dual mental state requirements are quite common. Many modern offenses require the government to prove multiple mental states in order to secure conviction. We're going to dig into all this soon enough, but for now, I want to zoom out and share another problem that the common law approach to mens rea has historically confronted: confusing the voluntary act requirement, which we just learned about in the last lecture, with mens rea requirements. You see, both a voluntary act and mens rea are necessary ingredients of criminal liability. But common law courts sometimes miss a very important point. They're not the same ingredient. I want to illustrate this point through a couple of scenarios. For the first scenario, let's return to the last recording, where I presented you with a situation of someone named Charlotte who is shooting at a target range. So in this scenario, Charlotte loads her gun, aims at the bullseye, and then pulls the trigger. At the very moment Charlotte's pulling her trigger, someone named David jumps in front of the target and ends up being fatally shot. So on these facts, I explained that Charlotte had acted voluntarily under the voluntary act doctrine because her muscular contractions in firing the gun were willed acts, which were the product of conscious effort and determination. But I also mentioned that Charlotte couldn't be convicted of homicide because she lacked mens rea, which is to say, she didn't have a guilty state of mind related to the death of the human being. Okay, what does this scenario teach us? Well, on the one hand, it may be true that a person's not blameworthy in the absence of a voluntary act. Causing harm via reflex, convulsion, or some other unwilled act certainly doesn't seem like an appropriate basis for holding someone morally responsible, at least in most situations. But it's also important to recognize that just because a person engages in a voluntary act doesn't mean they're blameworthy. Willing a bodily movement may be a foundation for moral responsibility, but it's an actor's state of mind as to the consequences of that movement which constitutes mens rea. This is an important point, and it can be easy to miss. So I want to illustrate it again with another scenario. Now I want you to imagine a mother named Danielle, who's at home in her kitchen when she begins to experience intense thirst. To quench her thirst, Danielle reaches toward the counter to grab a soda that's sitting on top. But there's a problem. At that very moment, Danielle's daughter, Lily, darts into the space between Danielle's hand and the counter, unbeknownst to Danielle. As a result, Danielle's hand smacks Lily in the face, with Danielle's wedding ring slicing Lily's face open. Ouch! Lily suffers a grievous facial injury in the process. On these facts, Danielle's hand movement toward the soda on the counter was clearly voluntary, understood in being terms of the product of conscious effort and determination. However, the consequences of that hand movement, that is, of slicing Lily's face open, clearly were not intended, understood in terms of being something that Danielle consciously desired or is in any way aware of when she began to move her hand. The key point then is that engaging in a bodily movement voluntarily is very different than intending, through that bodily movement, to cause harmful consequences. Unfortunately, courts applying the common law approach to mens rea often miss this distinction, confusing proof of voluntariness as to a bodily movement for proof of intentionality as to the results of that bodily movement. The source of the problem was one of the many problematic mens rea terms employed in the common law, the notoriously ambiguous phrase of, quote, general intent. Under the common law approach to mens rea, many crimes were said to require proof of a so-called general intent, yet the common law approach to mens rea also failed to provide a clear or consistent definition of this phrase. And in the absence of a definition, courts would sometimes stumble into saying things like, well, general intent requires proof of an intent to engage in a harmful act. And then the term general intent would invariably be interpreted or applied in a way that simply replicated the voluntariness requirement. The end result of this process was a lot of confusion and the potential for serious injustice for people convicted of serious crimes like assault for doing little more than willingly engaging in a bodily movement. That's unfortunate, but there's also good news. First, you won't make this mistake because you already know that voluntariness of an act is different than intending its consequences. More on the meaning of intent in a minute. Second, in this class, we're going to spend most of our time focusing on the modern model penal code-based approach to mens rea analysis, which does a very good job at avoiding these types of problems and confusions. As we'll discuss in the next recording, this MPC-based mens rea framework, known as element analysis, was carefully developed to specify the particular kinds of mental states that need to be proven to satisfy an offense's mens rea requirement. And that approach has since gone on to be widely adopted by legislatures and courts around the country. So in this class, we're going to focus on the model penal code approach with a particular emphasis on reading and interpreting mens rea requirements in criminal statutes. Third, and by contrast, we're not going to spend a lot of time in this class struggling to understand the judicially driven common law approach to mens rea. Whereas the MPC's reconceptualization of mens rea is widely considered to be one of the American Law Institute's greatest achievements, The common law approach to the topic is widely considered to be one of the greatest failures of 20th century courts and legislatures. Aside from confusing voluntariness with mens rea, the common law approach to mens rea is responsible for producing over 70 unclear terms and concepts, which ambiguously describe the mental characteristics that the government has to prove beyond a reasonable doubt. So for a variety of pedagogical reasons, we're not going to spend a lot of time in this class discussing this outdated and confusing approach. Among other teaching challenges, the common law approach is inconsistently applied by judges, and I believe that trying to understand that approach can make it even more difficult to get a firm grasp on a topic that's pretty challenging even without the conceptual baggage. So in this class, I'm going to be explicit about which common law mens rea concepts you're responsible for. And I'm only going to teach you ones that I think are particularly useful for you to know about in trying to understand the subject matter, in taking the bar, and to your career as a practicing attorney. With that plan in mind, I'd like to begin our journey into mens rea by presenting you with a clear overview of the two most important common law mens rea terms. Those are intent and malice. Let's start with intent. As you've already heard in this lecture, the term intent gets thrown around a lot in mens rea discussions. At the same time, it's often used in different ways, in different contexts, which can make things pretty confusing. So here I'd like to provide you with a clear legal definition of this term, which reflects the two most popular ways it's employed by common law courts. The first of those ways is to describe the state of mind of someone whose conscious objective is to cause harm. The second of those ways is to describe the state of mind of someone who's aware that harm is practically certain to result from their conduct. On this understanding of intent, therefore, a person intentionally causes some harm if they either, 1, consciously desire to cause that harm, or, and again, this is an or, 2, they were aware that harm is practically certain to result. Now I want to illustrate what each of these two alternative mental states looks like in practice. Let's begin with the first intentional mental state of consciously desiring to cause harm. Consider the following scenario. Chris says something offensive to David. Enraged, David slaps Chris in the face. In slapping Chris in the face, David consciously desires to inflict bodily injury upon Chris, which is to say, causing Chris to suffer bodily injury is David's desired outcome. On these facts, we can say that David intentionally causes bodily injury to Chris. Okay, so that's the first meaning of intent, consciously desiring to cause harm. Now let's consider an alternative mental state that will also satisfy the common law requirement of intent, being aware that harm is practically certain to result. Here's another illustration. Christina and David are having fun playing cards when a pesky mosquito lands on Christina's face. There's a problem. Dina absolutely hates mosquitoes. They're her sworn enemy in life. So Dina decides to slap at the mosquito on Christina's face, aware that in doing so, it's practically certain she'll inflict bodily injury upon Christina. Now, to be clear, Dina doesn't want to harm Christina, and she would much prefer to kill the mosquito without harming Christina. But Dina ultimately concludes that the mosquito must be killed now, while it's resting on Christina's face. So under these circumstances, where Dina is aware that harm is practically certain to result to Christina when she slaps at the mosquito, we can say that Dina intentionally caused bodily injury to Christina. Okay, so that's the common law mental state of intent, which again can be satisfied by proof that an actor consciously desired to cause some harm, or in the alternative, that the actor was practically certain some harm would result. Now I'd like to compare and contrast this common law mental state with another common law mental state that goes by the name of malice. Like intent, the term malice has a lot of different uses and meanings in the criminal law. But the most popular understanding of this mens rea term, and the one we'll rely on for purposes of this class, refers to one of three mental states. So the first two mental states that satisfy malice are the mental states we just learned. The intentional mental states of consciously desiring to cause harm, and the alternative of being aware that harm is practically certain to result. So the common law would consider someone who causes a harm intentionally in one of these two ways as also causing that harm maliciously. However, the common law also allows for malice to be established by proof of a third and arguably less culpable mental state that can be described as consciously disregarding a substantial risk of harm to another person. This third mental state is similar to the second awareness-based mental state that will satisfy intent, but involves a significantly lower level of awareness. So whereas for intent, the person must be aware that a harm is practically certain to occur, to satisfy malice, the person only needs to be aware that a harm might occur, which is to say that the harm is substantially possible, even if it isn't practically certain. Think about it like this. Dina, in the last hypo, was practically certain that in slapping at the mosquito on Christina's face, she would injure Christina. But now imagine a slightly different scenario. The mosquito is buzzing near Christina's head. So, in slapping at the mosquito in this new scenario, Dina is by no means certain she'll injure Christina. But she is aware that injuring Christina is a substantial possibility, which she consciously disregards when she slaps at the mosquito near Christina's head. This type of malicious but non-intentional conduct is similarly manifested by the impatient driver who speeds through a red light with a pedestrian beginning to walk into the crosswalk. And it's also manifested by the drunk college student who hits golf balls in the direction of a public playground occupied by children. None of these actors desires to cause harm, nor do they believe harm is practically certain to occur. But they're aware that harm might possibly occur. And because they consciously disregard a substantial risk of harm occurring, the common law would say that they acted maliciously. And that's true even if they didn't act intentionally. Though again, causing a harm intentionally will also satisfy the malice standard. Hopefully this distinction makes sense, but if it isn't immediately clicking, don't worry. We'll revisit it many times throughout the semester, including in the next lecture when we discuss the model penal code approach to mens rea. For now, I want to turn away from common law distinctions in mens rea requirements and instead focus on a category of common law crimes for which no mens rea applies at all. These are what's referred to as strict liability crimes. But wait, what are you talking about, Professor Sirota? I thought you just told us that mens rea is a fundamental requirement of criminal liability. Well, yes, dear student, that is what I told you, and what I told you is generally true. But just like all other fundamental requirements in the criminal law, well, there are exceptions. Exceptions to the fundamental requirement of mens rea are known as strict liability crimes. A strict liability crime is one for which the government can secure a conviction without having to prove a culpable state of mind as to one or more aspects of the social harm and offense, which social harm is captured by an offense's objective elements. So I'll say more about what social harm and objective elements are in the next lecture, but for now, I just want to give you a couple of examples. So the crime of assault of a police officer involves the social harm of injuring a police officer. This social harm is expressed through two objective elements: the result of causing bodily injury and the circumstance that the victim be a police officer. Along similar lines, the crime of public destruction of property involves a social harm of destroying public property. This social harm is expressed through two objective elements: the result of causing destruction and the circumstance that the destruction be caused to public property. A crime can be said to incorporate strict liability when the government does not have to prove any mental state as to one or more of these objective elements. So again, for the offense of assault against a police officer, this would include the fact that bodily injury would result and that the victim was a police officer. Or consider the offense of public destruction of property. This would consider the fact that destruction would result and that the fact that what is destroyed is public property. So the practical effect of any of these facts being subject to strict liability is that the government would not have to prove a culpable state of mind for them. And that in turn would make it immaterial that the defendant caused a prohibited harm, say a bodily injury or destruction, accidentally. And it would also be true if the defendant was reasonably mistaken about the key circumstances. For example, that the person injured was a police officer or that the property destroyed was public. Often, and as we'll discuss more in a couple of lectures, unavoidable accidents and reasonable mistakes preclude the government from proving mens rea. But for strict liability, there's no mens rea requirement. And so, unavoidable accidents and reasonable mistakes become immaterial. All that matters is that the bad thing in fact occurred, which, as you might expect, is not great for criminal defendants who may have acted reasonably, but it makes life a lot easier for prosecutors, who are no longer required to generate proof of a guilty mind. Okay, so historically, there have been two main categories of crimes that involve this kind of strict liability. The first are what might be referred to as public welfare offenses. Public welfare offenses were enacted in response to the breakneck speed of economic development during the Industrial Revolution. To deal with these societal changes, 19th and early 20th century lawmakers increasingly chose to strictly regulate dangerous or risky forms of commercial activity, including things like the production and labeling of food, milk, liquor, and medicines, the sale of securities, and the operation of motor vehicles. A defendant charged with one of these strict liability public welfare crimes is guilty regardless of whether he intended any harm or even if a reasonable person would have made the same mistake under the circumstances. The defendant is automatically guilty by simply doing the act, provided the government can prove that act occurred beyond a reasonable doubt. So, the U.S. Supreme Court has held that strict liability public welfare crimes are constitutional. For example, in United States v. Dotterweich, the president of a pharmaceutical company was convicted of an offense that prohibited shipping misbranded and adulterated products. There was no evidence in this case that the defendant knew or should have known that the products were in fact misbranded. But nevertheless, the defendant was held criminally liable because the crime he was prosecuted for was a public welfare offense that did not require mens rea. And the US Supreme Court effectively said that if this is what the legislature intended, well then this outcome is one that courts will enforce. Basically, the Constitution generally doesn't stand in the way of strict liability. And indeed, one of the most common offenses around is also a strict liability public welfare offense, speeding. To be convicted of speeding, all the government has to prove is that you were going over the speed limit. Were you reasonably unaware that you were speeding? Did you specifically intend not to speed? That might matter for human ethics, but it's irrelevant to criminal law because a government doesn't have to prove mens rea for speeding, because speeding is a strict liability offense. Okay, so public welfare offenses are one category of crime that have historically been subject to strict liability. The other category goes by the name of morality crimes. Morality crimes were first enacted to deal with changing sexual and societal norms during the 18th and 19th century. Illustrative examples of these kinds of morality crimes include adultery, bigamy, and statutory rape. So, to appreciate the strict liability nature of a morality crime, it's important to keep in mind that the critical aspect of this kind of offense is the legal status circumstance element that transforms what's normally innocuous conduct, for example, engaging in sexual intimacy or getting married, into a morally objectionable act. So, for example, in a statutory rape prosecution, the key circumstance element is whether one of the parties is old enough to consent. Likewise, in an adultery or bigamy prosecution, the critical circumstance element is whether one of the parties is already married. Because these crimes were treated as strict liability, the government would not need to prove that the accused knew or even should have known about these circumstantial facts. So, to illustrate what this means, let's focus on statutory rape, which again involves having sex with a person under the age of consent. Statutory rape is considered to be a strict liability offense in most jurisdictions because no mental state is required as to the age of the minor. This means that even if someone's sexual partner appeared to be well over the age of consent, and even if someone examined their sexual partner's passport to verify that they're above the age of consent, that person would still be guilty of statutory rape if it turned out that the passport contained a typo. Of course, if you were representing the defendant in this case, you might argue to the court something to the effect of, well, Your Honor, this is outrageous. There is no reasonable way under those circumstances for my client to know that the other party was below the age of consent. And you might be right. But it wouldn't matter because statutory rape is a strict liability offense. Even an entirely reasonable belief about age isn't a defense because no state of mind of any sort is required for the element to be satisfied. Which is to say, for a strict liability crime like statutory rape, you would act at your own peril of being wrong, no matter how reasonable a belief may be. The same can also be said for morality crimes like bigamy and adultery. So for example, a defendant was traditionally guilty of bigamy even if he didn't know he was still married to his prior spouse when he remarried. In which case, a defendant who reasonably believed that he had been lawfully divorced, but his divorce was in fact invalid, would still be guilty of bigamy. Likewise, a defendant would be guilty of adultery, even if the defendant has an honest and reasonable belief that he's no longer married at the time he has an affair with another person. So look, this is obviously some very strong medicine, not only because strict liability seemingly makes a criminal out of someone who's trying to be careful, but also because it conflicts with the fundamental ideals that animate our criminal justice system. Generally speaking, mens rea is rooted in the retributive idea that someone who doesn't choose to cause social harm and who otherwise isn't morally to blame for its commission doesn't deserve to be punished. However, mens rea requirements can also be explained in utilitarian terms. Arguably, for example, you can't deter someone from criminal activity unless they're aware that they're actually engaging in criminal activity, and that punishment lies in store for them if they continue to persist in their actions. So, from the perspective of deterrence, punishing someone in the absence of mens rea might be considered ineffective and wasteful. Along similar lines, it could be argued that someone who causes harm accidentally, rather than intentionally, isn't dangerous enough to be incapacitated or to need to be rehabilitated. Now, to be clear, these are broad simplifications. There certainly are utilitarian arguments that can and are made in support of strict liability. But the bottom line is that strict liability is controversial and sometimes strongly disfavored. Because of this reality, courts are particularly careful before they interpret a statute to allow for strict liability. One important tool for doing this, and the last thing we're going to learn about in today's lecture, is called the presumption of mens rea. The presumption of mens rea basically says that when courts confront a statute silent on mens rea, they should not assume that the legislature intended for the crime to be one of strict liability. Because mens rea is so important and has such deep historical roots, courts instead assume, in the face of legislative silence, that the legislature intended for a mens rea to be read in, hence the presumption of mens rea. So, for example, imagine an offense and simply reads, "No person shall cause bodily injury to another person." All right, so there's no mens rea in this statute, but that doesn't mean the courts would construe it as strict liability. Instead, they would likely apply the presumption of mens rea and read in a culpable mental state requirement. But which one? Well, that's a complicated question with no clear answer as a matter of common law practice. But for purposes of this class, we'll practice reading in the common law mental state of malice. In which case, the government could only secure a conviction for this assault statute, even if it's silent on mens rea, if it can at least be proven that the defendant consciously disregarded a substantial risk that the bodily injury would occur. Now, alternatively, proof that the defendant intended to cause bodily injury would also suffice, right? Because intent, as we learned, provides an alternative, more culpable basis for establishing malice. All right, so far so good? I hope so. Now I want to discuss where things can get tricky with the presumption of mens rea. As I previously mentioned, the presumption of mens rea is ultimately a presumption about what the legislature intended. And since legislatures have historically intended for mens rea to apply, courts believe it's appropriate to read mens rea in even when a statute's silent. But, as we earlier discussed, there are two kinds of crimes that have historically been subject to strict liability: public welfare offenses and morality crimes. So when courts are presented with statute that's silent on mens rea, which falls into one of these two categories, well then they won't apply the presumption of mens rea. Because the presumption here, based on historical practice, is that the legislature wouldn't have intended for mens rea to be read in. All right, so in practice, identifying morality crimes for purposes of figuring out whether the presumption of mens rea applies is pretty easy. Basically, you just look out for statutory rape, bigamy, or adultery. By contrast, determining whether a statute states a public welfare offense to which mens rea would not apply, well, that can be a bit more challenging. To make that determination, there are 4 common factors that courts look at and that we're going to apply in this class to work through whether the legislature intended for a statute silent on mens rea to be treated as a strict liability public welfare offense. First, we're going to ask whether the criminal statute is regulatory in nature. That is, does it deal with the pathways of commerce and industry, as do, for example, laws governing driving on the road, the handling of food and drugs, and working conditions in factories? The more regulatory in nature a crime seems, the more likely it will be categorized as a strict liability public welfare offense for which the presumption of mens rea does not apply. Second, we're going to look to whether the penalties are relatively small. That is, think jail time or 1 to 2 year maximum prison sentence. All else being equal, the smaller the penalties, the more likely it is that a crime will be categorized as a strict liability public welfare offense that isn't subject to the presumption of mens rea. Third, we'll ask whether a conviction for an offense would do grave damage to an offender's reputation. The idea here is that strict liability public welfare offenses typically are not viewed by society to be as serious or immoral as traditional common law offenses to which mens rea does apply. So, the less reputational damage caused by a conviction for a particular form of conduct, the more likely it is that that form of conduct will be categorized as a strict liability public welfare offense to which the presumption of mens rea does not apply. Fourth and finally, we're going to ask whether the volume of prosecution for a statute is so high that mens rea requirements could disrupt enforcement. As previously mentioned, strict liability public welfare offenses, like speeding, are often high volume offenses for which prosecutorial efficiency is really important. So, all else being equal, the higher the volume of prosecution and the more important prosecutorial efficiency are for that crime, the more likely it is that the crime will be categorized as a strict liability public offense to which the presumption of mens rea does not apply. So, to recap, the 4 factors that we'll use to determine whether a criminal offense silent on mens rea is subject to the presumption of mens rea are as follows. First, the regulatory nature of the crime. Second, the severity of the penalties. Third, the stigma associated with conviction. And fourth, the volume of prosecution and the need for prosecutorial efficiency. So one of your class assignments is going to require you to apply this 4-factor framework to a statute silent on mens rea. And we're going to review this assignment together in class. But as you conduct your analysis at home, please keep in mind that the application of this framework, just like any other aspect of statutory interpretation, is as much art as it is science. So you shouldn't expect clear answers identified with mathematical precision. The best you can hope for are compelling arguments going in one direction or another. Another thing that I want you to keep in mind as you apply the framework is that these factors, like any other interpretive tool, are ultimately about legislative intent. So you'll also want to keep an eye out for other indications of legislative intent. So for example, maybe legislative history provides some indication of whether the legislature intended for a statute silent on mens rea to be one of strict liability. Or maybe there's something about the statute's overarching purposes that could be argued to be relevant to the strict liability analysis. Finally, note that for mens rea ambiguity in a criminal statute, just like any other interpretive question, the rule of lenity could be relevant. So for example, where the evidence of legislative intent points in both directions, a thoughtful defense attorney could argue that the court should reject strict liability and read in mens rea as the narrower construction of a criminal statute. So in this sense, a presumption of mens rea and the four-factor analysis complement, but don't completely supplant the other interpretive tools we've already learned how to apply this semester. Does that make sense? I hope so. Because that, my dear friends, brings us to the end of this lecture and to your introduction to the topic of mens rea. With that, please go ahead and try the readings and class assignments. I'll look forward to discussing them with you and exploring the topic of mens rea in greater detail when I see you in our next class. Have a good day.